Senior Citizens Act. Yes. They have informed the other side. Inform other side. Group 6. Hearing.
For indication, my lord, the matter which on 8,025, but the matter is not in the case.
Non-possible. To be mentioned.
For judgment item number 1.
The CRR 482 of 2022 is thus dismissed. Connected application and voting are also done.
Item number 2.
Grant 3 of 2025 is also dismissed. Grant. Review.
Item number 3.
Item number 3 and this is application for restoration. But grant 4 is the application for restoration, and grant 5 the section 5 of restoration. So there is a deal. Kindly restore my application. Main application is the conviction 6-1.
Within time.
No, but that's
So 1116 days.
change.
How you can explain this delay?
The change being
Maybe, but you have to explain the delay. 1000 delay. How I can
Kindly come to can 5. Error 3, 4, 5. Explain everything.
You are not diligent. Why advocate only inform you? Why advocate will inform you? Why you are not diligent in your own case? You slept.
Layman.
Layman. You know the Supreme Court judgment nowadays delay cannot be.
There is a judgment passed by the Supreme Court. When there is a 100 days delay, honorable expert, honorable section. Something down.
Now, what is the main matter?
While this revision application, there is a conviction for 6 months under section
350.
Oh.
What is the ground of challenge of that? No, I will hear you. Both. This is the matter of 2010. 16 years has already been passed. You submit on your merit. Yes. What about the invitation? I will hear the matter, main matter. No, no, no. I will restore and I will hear the main matter. When available. You are ready, you feel you start. Okay. Twenty-seven.
27.
You will be prepared yourself, you also prepared. 16 years old matter I have to dispose of. Yes, affidavit of service filed.
After conviction,
Let him submit first. Thereafter I will see if there is need. You have challenged the regional order or appellate order? First appellate order.
the conviction of
Trial court.
but
Trial court order.
I came for your lordship for confirmation of bail.
Confirmation of
Bail. 350 for 6 months conviction.
bail was not granted.
Granted, madam.
After conviction, bail was granted.
I came up with your lordship for confirmation of bail. On a revision form, madam.
No, you have already convicted. Then question of bail confirmation.
I will send your lordship for
You have already obtained bail after conviction. Now the matter will be decided finally whether your conviction was rightly held or not.
but 27 but
Yes. Item number 4. What is the main matter? Do you have CD?
Yes.
Yes, proceed main matter. No, in this way I cannot restore the application. You move the main matter, I will restore and I will hear the main matter.
Pass it over.
You know, whenever I will take up the restoration application, I will dispose of the main application. Again, it will kept pending for long. 2023 matter. This is
On Monday.
Monday I will not be available because I am sitting only on Friday to take up the regional application. Friday. Okay. Affidavit of service. Here to be prepared. I will hear the matter. And please bring the CD on the
Item number 5.
I'm waiting for the petitioner to file an application for extension. May kindly extend the interim order for limited period and fix it for your term.
2012 matter, madam.
Your Lordship,
What is the main matter?
Lordship, in this matter, there was an incident inside the currency chest of a bank. Two of the security guards were stationed in the currency chest of a bank. There was a power failure. They switched on the portable generator, which was positioned outside the currency chest. There was an obnoxious gas which emitted from the generator, and these two security guards died here. Therefore, the family members of the two security guards have initiated a proceeding under section 334 of the Indian Penal Code against the employees of the bank, saying that they have caused this. The incident has occurred because of the employees of the bank.
Negligence of the employee of the bank.
The petitioners are the employees of the bank.
The negligence of the employee of the bank.
The charge sheet has been submitted by the 304 Code of Indian Penal Code.
2004, this matter is pending.
Lordship, Mr. Doshi. Uh,
12. Are you ready?
Your Lordship, I am seeking for an extension of the interim order and kindly fix the matter with any time in
Today
April.
itself is a fixed matter. Where is the problem?
Your Lordship, may kindly fix it any time in the month of April, Your Lordship.
Simply taking extension.
Extend the interim order for a limited period and fix it for your Lordship. We also want to do the matter, Your Lordship.
Interim order till when?
Your Lordship, interim order was till December 2025. The page number 8 of the CRAN application, and the application has been filed beyond time, Your Lordship, after 1 month.
I will kindly fix it.
Interim order expire on 3rd March.
No, Your Lordship, it's December 2025.
December 2025.
Beyond time,
Beyond.
so 1 month they have.
1 month. Because the last interim order was given in September 2020.
Let him come first. Other side come first. Fixed on 5. Not good. Not good. Have you solved the copy?
Your Lordship, let us hand he is appearing for the opposite party.
No, you have to solve the copy.
Yes, sir, Your Lordship. This is the application. Yes, sir.
Next day you place the affidavit.
Your Lordship is fixing the matter well.
Not fixing. Next day I will hear.
Item 6.
Yes.
Order expired. And before that, I will file an application for extension. The case number of the petitioner was as well fixed matter, and he was deciding and constructed house. My lord, that meeting.
You are moving the main application.
Yes, sir.
You are moving the main application.
Yes, my lord, your lordship. He is my lord saying, and keep the another question.
Affidavit of service file.
Item 7.
Plan certification. Well, I have got a big part.
And this is another within time manner existed. Macro 2020. Can you changes or and whether document can be next day report is calculated. What name? Another document.
Line 2. Same order. Line equal to bottom.
Item number 8. Compare the opposite party.
I is not here. It's not good.
Item number 9.
Same.
Item number 10.
10 is not this one. Not this is written.
Item number 11.
Not good. Assignment.
Item number 12.
Not good.
Item 13. Purchase funding value at lake. That is value.
Actually,
Australia, manager, Australia.
you have raised the point of territorial jurisdiction of lodging the complaint.
But she was not, I thought we have also seen. Now, my assessment is subject to law. Yes. Yes, I will ask. Look at the. What bola hai na? Will I do with the state
Monday. Where is the CD? CD is required. May I pass over?
But here, in the meantime, I get some. If my learned friend is very clear, issue of jurisdiction, then I will only restrict myself on that. I will not get into any other issue. I hope my learned friend is only restricting himself to the territorial jurisdiction.
Territorial jurisdiction and the person who lodged is not the competent person to lodge the complaint.
That perhaps
Two issues he has raised.
yes, these 2 points.
2 points. Number one,
Now kindly see section 190 of the CL.
You have also challenged the order. What is the order?
Yes. There is no way for washing.
You have come here, the prayer is an application for passing of order passed on so
Something valid in this order. So Lordship comes to the first page of the order sheet. Dated 1/6/23. Now the order number 1 was passed on 2/5/23.
2/5/2023.
Because the case was started 1/6/23. At the top of the order sheet. But I don't know whether that I do not know. I once the certified copy I have the kind was right. There seems to be a correction.
Ram Dayal, Homeless Kumari,
An application for watching the order. Passed on.
an application under section 482 of the Code of
Then
Criminal
whether an application for watching the order was
on 2nd May 2023.
whether any endorsement on the site reflecting the need payment for correction.
No, already they are typed. It was typed.
Site.
It was typed, not initial. It was typed.
In R it is by hand.
That is.
Okay, that's some approach or like. So it is only this order which is under challenge.
Yes.
The order dated 2nd of May.
Receive, yes, come to the order, please.
Well, that's at page. That's the certified copy. After page 15.
The direction was investigation officers shall carry forward the investigation as per the modalities of law and submit his report following the mandate of Code of Criminal. This is the direction.
156 or
156 clause.
Oh, received the written FIR along with formal FIR. This is just the first order. Can you see that? Then how is it subject to challenge?
Can you see the challenge? Can you see the date at the top? 1/6/23. This case was started. Order was passed from 2/5/23. Before the case was started. And it is the FIR.
That your lordship can call for a report.
Not a complaint.
That may be a mistake. That may be a typographical or
There may be a mistake.
mistake, yes. Because the order cannot be passed after before the initiation of a yes, true.
Because on the FIR, your lordship will find the endorsement of the magistrate as seen 2/6. Just 2 pages there.
Yes, 2/6.
So what is there to be quashed or what is there to be challenged in this order with the learned friend has to file an appropriate application. He has not filed an appropriate application. This is a challenge against an order by which the police has only forwarded the FIR.
That is totally wrong.
How what is the act of recording of receipt of an FIR from the police in terms of section 157 CRPC? How can it be wrong?
No, what is why the trial court has referred a judgment youth bar association of
That is
India?
that it is to be uploaded on the website, police website. That's all.
Charge sheet has been submitted. He only forwarded the FIR before the
Yes,
magistrate.
that's all. Then even if this, let us assume, even if your lordship sets aside this order, does it mean
Either you have to challenge the FIR or the proceeding.
charge sheet has been.
Either you have to challenge the FIR or the proceedings.
Yes, that has not been done.
This is only a forwarding a FIR before the trial magistrate before starting investigation.
But,
This is only a forwarding of a FIR before the magistrate before investigation.
but the learned friend has to file an appropriate application.
Yes. Your application is not in proper form.
Because I was challenge the for washing. Washing.
Where is quashing? You see where you have prayed for quashing of the proceeding or FIR.
I have said, don't say,
You did not state anything in your paragraph, in cause title, even in your prayer. Anywhere you have.
At page 11, it was corrected with the leave of the honorable court around 96.
It only means the order by it should not be quashed because that's there in the cost item. Washing of an order. Washing of what?
Leave may be granted to him to challenge the FIR.
He can always do that, but there is no requirement of leave. If the application is without merit, is not in form, then my learned friend, it will be dismissed. He already has the liberty.
You can file fresh.
I recommend taking the certified copy.
The certified copy can be returned. If my learned friend does not wish to proceed.
You can add only FIR, passing of FIR in the first title. That liberty I am.
The affidavit portion remains. There is no prayer there. The affidavit portion, my learned friend has affirmed with regard to the above there. In that
No, awardment is there. Grounds are also there.
ground, well, what is the ground? Kindly sees para 18.
The initiation of first information report is bad in IR.
Subsequent passing of the order of the learned
And
magistrate.
FIR is beyond the territorial jurisdiction. Everything is mentioned.
Passing of the order of the learned, well, paragraph 18.
No, before that he can add application for passing of the FIR and order dated so and so. That is sufficient.
Kindly sees page 7.
Page
Page 7.
7. Yes.
Paragraph 7.
We are satisfied with the initiation of FIR
Paragraph
subsequently
17,
passed
my
on
lord. Paragraph 17.
17. That is the order. Both he has.
There is no order of taking cognizance. In paragraph 17, he says the learned magistrate has taken cognizance. Then, being agreed by and dissatisfied with the initiation of the FIR, subsequent.
File a fresh application because there is some discrepancies in your application, not in proper form.
In fact,
Yes.
also because it is what while
Here, the council application. Yeah.
item 14,
14 I am for the officer, 14 I am for the state.
14 I am for the petitioner, led by Mr. Montager to this matter, praying for a day that.
No, I will not allow.
Lord, has been 96 the Lord.
I will
Last
not
order.
allow on any of
Last order. 20th of February 2026, Lord, it was fixed at the top for hearing. Because Lord,
that's why I am not allowing.
I have started.
Because the matter is appearing at the top.
Just
And
one.
only on the mention of the learned council, this was upgraded and fixed at the top.
I'm deep to this, just one.
So in this way, I will not allow.
Today, Mr. Montager is out of station.
Maybe.
He won't be able to argue the matter.
Last occasion also you took adjournment.
Last occasion, I had opposed the extension of entry order. Last occasion, they extended the entry order till 27th of February, fixed the matter on the 20th of February, saying that it will be done today.
Very well.
It will be done, my lord, at the top. Now, my lord, what is the issue, my lord, what we are facing, my lord? Is that using this interim order, other proceedings of mine, my lord, they've all been stayed.
No, Milord,
Every
as a matter of
Let us start, my lord,
Milord, I am not briefed in the matter, Milord.
then I will not, then let me place my case.
Milord, because Mr.
Interim order already vacated.
Milord, Mr.
Interim order already vacated.
They file another kind of application.
Just one. I am not pressing the current application today, Milord. I am praying for a simplicity adjournment because
Okay, not today, as the last chance.
Doctor,
The
record.
prayer of
Why?
appearing
I am not moving
on
it.
behalf of the petitioner.
Because I could have started today, because they had concluded, they had.
No, this matter has been fixed at top. This matter has been fixed at top. He must be prepared.
I am on the very Milord, due to some unforeseen
Next time you ask him
I
to
am
be prepared and come.
I am deep. I'm deep.
I'm ready.
I'm deep.
Item number 15.
Very clear, Your Lordship, Milord. Milord, interim order is 27th, Milord, that matter, Milord, where the first thing the Lordship direction, Milord, I challenge, Milord, I deposited, Milord, 25% of the amount, Milord. And accordingly, Milord, Lordship of Christy, Milord, in that condition, Your Christy, Milord, passed the interim order. First of all, it was Milord, in the disposal of the national application, and Milord, thereafter, Milord,
138 matter.
practically, Milord,
The trial court has dismissed your application.
and we got an appeal before the appellate court, Milord, and appellate court, Milord, without hearing, Milord, passed an order during the COVID-19.
Only on the condition that you have not complied
Yes, that is
the
the pandemic period. That's why, Milord, against that order, Milord, I have come up with.
So I am remanding this
Fine.
matter.
Fine.
Yes, Your Lordship, I am for the opposite party number 1 in this matter. If Your Lordship would permit to pass a direction on the learned court below for speedy and expeditious disposal of the matter
Yes,
after remanding.
Last occasion, Your Lordship, were going to do that, Milord, by that time, I will file my order and original. But Milord, now is a case where everything, let everything be taken over there, Milord. Because the substantial points are there. Appellate court has not gone into that.
Yes, that should be decided on merit.
Yes. And we have already.
So I am remanding back to the first appellate court to decide this appeal on merit. You have already deposited 25%.
And we have filed also compliance report, Milord, for your, that is on record by your appeal.
Your Lordship,
Yes,
kindly pass a direction for like specified time period for.
definitely.
I have also prepared with the brief notes of argument and the judgment.
And it could be said, yes, possible.
Not required.
Upper limit cannot be.
The plan,
Item 16, that is my application. I am appealing. Under petition number 8 already expired. Lord, this is a case of the district of Coachbihar.
so petition number expired.
Yes.
So report may be called for either.
No, but I am submitting, I think my another.
Report is required.
Malad, in same incident, 4 cases are pending. Where for amalgamating hearing of 4 cases has been rejected against which this application has been come and first application.
First application be
Application
cured.
before the circuit bench. So can it be transferred to the circuit bench? So both the matter can be heard analogous with this criminal petition and criminal petition 243 of 2023. That is also pending stage there. Also. This is my prayer. Already. Then
I will see the order in order number 5, 8th of July 2008.
This is matter of which police station? Kuchbihar.
yes. This is Malkama.
2008 matter. So
Shikal police station.
I do not know what is the stage of the
Stage and submitting. Stage is one already charge sheet has been submitted. Trial has been stalled due to the stay passed in another criminal revision application.
you file the present status of the
Yes.
proceeding.
But where?
item 17.
Can it be taken up?
Already hard in part.
Because the conviction is for 2 years. Now, this something which was not considered is whether it can be reduced on probation. And the only argument.
You conclude your submission. Appellate court has affirmed the conviction.
After the appellate court, a revision paper. Normally, the Honorable Supreme Court says that the trial court as also as the appellate court are required to consider whether he can be registered probation or not. So this is the judgment panel. Panel comes to page 26. Because I think since that has not been considered, the matter should be remanded. That is panel.
The trial court has not allowed the prayer for.
Trial court has just one line, cannot be registered probation, but the appellate court has not considered.
You have submitted before the appellate court.
But that is not reflecting on the judgment that it has been considered.
So how you at this stage that
No matter
at this stage can be allowed?
my lord. That is what can we see judgment of final justice.
No, this can be allowed at this stage.
My lord. That is mandated. No prayer is required.
Where is that?
Now can you come to page paragraph 26?
This was your first commission of offence.
First, no other criminal.
What was the age at that point of time?
Well, he was around 35, 40.
35, 40.
It was a dispute.
What was the allegation?
My lord, it was a dispute between Kasim brothers over installing a electric meter. Now they stated that 3 persons were accused. Now those 3 persons were also convicted. The appellate court said that only those 2 persons were acquitted. The conviction against this person was there. Now during the course of investigation, during medical examination, they said assaulted by relatives. Now 161 before police.
So why you are placing this judgment for probation after 11 years?
My lord, I have done. And now after that, my lord, during investigation, assaulted by all 3. Now in trial,
On merit you are placing on merit, or you are
I
placing
am only on my lord, now I am on my lord,
release on probation?
probation.
Can it be done here?
My lord, it can be done here, as also it can be remanded back to the appellate court for considering that. The my lord comes to paragraph 26.
Be done by your lordship also by 36
It can be done also by
After 11 years. Paragraph?
paragraph 26.
Yes.
On consideration of the precedents and based on comparative study of section 36 and subsection 1 of 4 of the provision, what is revealed is that the latter is wider and expansive in its coverage than the former. Interiorly, when section 360 limits release of an offender more than 20 years old on probation when he is sentenced to imprisonment for less than 7 years or fine. Section 4 of the Probation Act enables a court to exercise its discretion in any case where the offender is found to have committed an offence such that he is punishable with a sentence other than death or life imprisonment. Additionally, the non-obstructive clause in the subsection gives overriding effect to subsection 1 of 4 over any other law for the time being. Also, it is noteworthy that section 361 CRPC itself, being a subsequent legislation, engrafts a provision that in any case where the court would have dealt with an accused under the provisions of Probation Act, but has not done so, it shall record in its judgment the special reason thereof. What logical
Reason has been not assigned. Reason has not been
No.
assigned by the trial.
What logically follows from a conjoint reading of subsection 1 of 4 of the Provision Act and section 361 CRPC is that if section 360 CRPC were not applicable in a particular case, there is no reason why section 4 of the provision
Probation Act would not be attractive. Summing up legal position, it can be said that while an offender cannot seek an order for grant of probation as a matter of right, but having noted the object of that the statutory provisions to achieve by grant of probation and several decisions of the court on the point of applicability of section 4 of the Provisions Act, we hold that unless applicability is excluded in a case where the circumstance stated in subsection 1 of section 4 of the Provision Act are attractive, the court has no discretion to omit from its consideration release of the offender on probation. On the contrary, a mandatory duty is cast upon the court to consider whether the case before it warrants releasing the offender upon fulfillment of these stated circumstances. So, madam, it's a mandatory. What are the circumstances required to fulfill? Madam, it's 2 years. Conviction is for 2 years. Now, madam, more than 10 years is elapsed. Now, it's a dispute between a family over. Now, during the course of in the trial, what they have stated in trial, that is for the first time. They have stated this person assault. While during investigation, he stated that all the persons assaulted. Now, so it is development of their story, prosecution story. Now, madam, the question of grant of probation could be decided either in the event the court in its discretion decide to extend the benefit of probation. Where you have shown that the appellate court can grant probation. I'm coming. However, if the answer is negative, it would be only just and proper for the record the reason there. For the following reasons, in the light of the factual matrix, we are unhesitatingly of the opinion that the Sessions Judge and the High Court, by omitting to consider whether the applicant were entitled to the benefit of probation, occasioned a failure of justice. Consequently, there was no worthy consideration as to whether the applicant would be extended the benefit of probation. So, madam, the trial court as also as the High Court, it has been said the appellate court. Now, madam, the appellate court has not considered that. We are conscious that in MC Supra, since followed in the state of Madhya Pradesh versus Mansi, this court has held that the report of the probation officer referred to in subsection 2 of section 4 of the Provision Act is a condition precedent and therefore must be complied with by the trial court and the High Court. Importantly, it has also been held that the courts may not be bound by such report. In view of the matter, we need to make appropriate direction. Accordingly, while maintaining the conviction recorded against the applicant, but looking into the facts and circumstances, we are inclined to limit the matter of the High Court for limited consideration of the question of grant of probation to the applicant upon obtaining a report of the relevant probation officer, which is ordered accordingly. So, this case relates to 498A 304B. They were acquitted under section 304B. They were convicted under 498A 4B. So you want to remand back to the trial court and obtain order from obtain a report from the probationer officer. Thereafter, he will decide.
Even your lordship, in revision me.
But I have to call for report from the probation officer.
Also call for a report from the probation officer and consider the same.
Which district?
How?
Either my lord can call for the report or my lord can remand it.
My lord has the power. The lordship has to.
So
This is subsection 4.
because it is what this judgment says, because it is for the appellate court.
No, yes, that is there.
But we have to see the probation officer report.
Statute says that an order under this section may be passed
Either by the trial court or high
by
court.
any appellate court
By the either
or by the High Court or the Court of Session when exercising its powers of review.
So I'm remanding back, he will collect the report and thereafter.
Uphold the conviction, send it back only on the limited point of that probation officer's report.
Which provision you are saying?
Subsection
2.
Subsection 4.
And the report will become negative, then what will happen?
Then we will have to suffer the consequences of because if it is negative, but report is not bound by the report of the probation officer.
But
Report is-
report must be.
Report, report is subjective satisfaction.
So you are not moving on merit.
Because I moved on merit because my grounds, but
You
this is.
cannot leave on. Either you have to choose one.
Even if I move on
If
merit.
you move on merit, then
Yeah, no merit.
you move on merit. Otherwise, you have to accept conviction was right. Now remand back or take a decision on the point of probation after getting the report from the probation officer.
No, my lord.
That is your choice.
No, my lord, also upon the conviction.
No, when you are submitting that we are entitled for probation, that means you are accepting your guilt. You are accepting the conviction of the trial court.
My lord,
Once you are pleading or your submission is made, that trial court not considered, the sessions court also not considered, though they should have considered. So you are harping on the point of probation. So now if you are stick on the probation, then I will send it back to the trial court or I will myself call for report and I will decide. Now if there is negative report, then the consequence you have to face.
my lord, negative. My lord, because the
We cannot say the report of the probation officer, we cannot presume also the positive report will come.
I will pray for my lord to remand it back because otherwise I will lose the court. Because my right is before the appellate court.
So you want to remand back and only on the probation. Yes, we can do it. Okay, I'll pass the order. Hearing concluded.
I mean, can it be checked on the tape whether if I find something in
10th, I have kept 10th.
if I find something on Mary, any child.
This way you cannot proceed a matter. You have to decide first what do you want. If you want,
But it keeps it on the tape.
after hearing conclusion, everything done,
That keeps it on the tape. But if I can satisfy my lord on merits, I will satisfy or I'll pay for demanding.
okay, 10th, keep it. What to come.
Me?
Item 18,
Give that judgment. Give that judgment.
item number 18, for the petitioner from this matter, this is a 138 matter. The petitioner is around.
Why not today? Why you are praying not today? This is the matter pending since 2016. Let him submit. No, I will not allow. This is the pending since 2016. You take down, he will submit.
In fact, my submission.
Hearing concluded on the part of petitioner. I have already heard.
Only to reflect, this is a 138 matter. The issues are that these persons are non-executive directors. One of the petitioners was a full-time director, but he had resigned prior to the issuance of the check. The only one-time director, he resigned prior to the issuance of the check. The others are non-executive directors, and to
One director was resigned on 5th January 2013.
So, but that and the others are all non-executive directors.
And all check were post-dated check. Yeah?
Yes.
And petitioner number 5 also resigned.
Petition number 5 was the only.
Petitioner number 5 also resigned on 30th July 2013. So two directors were resigned.
But the petitioner number 5, Gaurav Mahindra Doshi, but he was the full-time director. He resigned prior to the issuance of the check. And the others are all non-executive directors. We have annexed the annual report of the company.
Only one director resigned.
Only one.
When 15 January 2013 or 30th July 2013.
I was supposed to file the RC report. And today I'm making it.
Last occasion you also
No, last day,
adjournment only on
last
that
day, the document LRC said that they need to file through evidence. Last day, you lose the LRC said that they need to file through evidence.
After that 2 months already over.
First prepared, it will be carried. That is why. Second half, you also was supposed to see first half. Only this problem.
Not today. Not today. Next day. Copy should be handed over in advance.
Item 19.
Actually, I have served on the opposite partner. Gradual extension.
Yes.
Yes, gradual.
I am not concerned about CRAN. I am concerned about the main application.
The main application, I feel everything is pretty difficult. I don't actually see the earlier order.
This is appearing under heading contested application.
Kindly takes up the earlier order, might not be recollect what is the issue. That case diary not.
So this way, how long this
The last occasion was that I had requested your lordship for a intervention in this matter. If my lord directs the lower court to send down the NCR, my lord will dispose of it, seeing whatever there is on the NCR. So CD, I believe it is not available. They have tried cheap.
LCR has not come.
No, let the LCR come on the next date, my lord dispose of it. Because I am also facing a difficulty because on each and every date I have to file a grant application, my lord has to extend it. And the dates are falling within the lower court also. Because case diary is not traceable. Also before the lower court, case diary is not traceable. That's not really. SC matter. And the LCR will serve the purpose. Pause it for a limited period of time and dispose it.
Case study was called for last occasion.
Under whose petition it has been called? State has submitted a report also. And from the date the original order was passed,
1 minute.
not for a single day the de facto is okay in this one.
What is the allegation against him?
And the allegation stems from a civil suit. The de facto complainant was at that point of time when the complaint was lodged, was the secretary of SCST Council. Now the SCST Council was a tenant, even licensee holder in the premises where the whose landlord, the owner, is the petitioner hearing. After a period of time, that tenancy agreement became void because of the dues that were paid. Now civil suit was instituted in civil court Calcutta. In that suit, and permanent injunction was given. In the meantime, to bypass that, because they wanted the tenancy to continue, and we did not want to give the tenancy. So there was no ground before the learned civil court. So they, being an SCST count, because SCST Act gives a certain number of provisions for it. Now, can we see the section that is there? This section is
3ZA
yes.
bracket A.
Yes, well, this section when I kindly I do not have the SCST Act which way. But this section is not allowing a member of the scheduled caste and scheduled tribe to access a toilet. This is the offense.
This is the only allegation.
Yes. Now the toilet that is in question, when my lord will go through the entire thing, that toilet is in question, is not within the control or the domain of the present petitioner. It was not a private toilet. The entire building is not owned by the petitioner. Common toilet was used for many tenants. Now they had lost their tenancy, so the toilet was blocked automatically. Now they could not find any other reason in the civil suit, so they went up for a refund. And thereafter
Came before this court for passing of the
washing. And from the day one, kindly see from 2017, we go back. I think this is
how the trial court record will help you.
my trial court record will help us. My lord wanted a case line. Case line is not with the investigating officer. They have tried their level best. Now they say that TCR was given to when the charge sheet was filed. It was given to the learned trial.
Charge sheet has been submitted.
Yes, charge sheet has been submitted.
You did not have
Yes,
copy
I have
of
the
charge sheet.
Yes, it is. Well, can you see the CRR? Can you see the CRR? Annexure.
You are appearing for whom? State. Who is opposite party?
The opposite party has been page number 20 is the charge sheet. Well, from 2017.
Whether you have served the copy to the
Yes, I have served the copy on every occasion. We have served the copies from 2017.
They are not on
2025 dates. Yes, they were approved. The reason for which, because the original issue that was, it has been resolved.
So where from you can show that the toilet was not under your control and that toilet was that toilet was common toilet for other tenants also.
But I have to then start the matter on merits.
Merits, but from where you can show, either from the any paper can you show that? statement was there? Any statement, copy of the statement? Huh? A copy of the statements recorded by the investigation officer is available with you.
No, man. That is because 207 papers was not given at that point of time. Till today it is not given. Kindly see the last order sheet. That,
You have not received a copy of
No,
207.
that is the reason why the CD was called for. So what is the update? That is the reason they have given a detailed report to the fact that CD is not available and this is the current status. That is the reason why I am asking your lordship to kindly bring forth the LCR. My lord will appreciate on both ends and finally dispose it of. Because this is primarily on civil. I will show the lordship.
What is the status of that
Pending.
pending and interim order is still there?
My interim order on the last occasion, my lord had passed in the month of the grant application, 9th of January.
16 till 16th January last interim order was extended.
6th February. Yes, my lord. Thereafter, my lord, I filed because the matter was actually pending before your lordship. My lord could not sit, so thereafter.
Within time we have filed.
Thereafter, I had to file a fresh grant. On the last occasion when my lord had taken up, my lord had told me this kindly file a fresh grant. It was pending. I believe that
Up to 6th February
Yes,
there
sir.
was an interim order.
Yes, sir. This time I have filed in the section just after the 17th February month, just next week.
Where is the affidavit of service?
See, I have served, my lord. The service is not here with me. It has already been posted. It is there. I can
You
give
have
it
to
today.
file this affidavit.
But I'll give it today. In the course of the day, I'll submit the affidavit of service. I have the track report with me. I just
Track report. Where is the track report?
but print off. I'll take a print off because I don't know.
I am keeping Passover.
Passover.
I am keeping Passover. I will pass the order. This is the order.
Well,
You bring the track report.
I'm bringing the track.
You come at 2 p.m.
2 p.m.
2 p.m. I will take up this matter. And in the meantime, if you can affirm the affidavit
I
of
have
service.
to get it upon. Otherwise, I'll just send out a track. Okay. What is it?
20 and 21.
20 and 21, I'm for the petitioner. I'm appearing online because I got to know my lord is angry with me. So I'm
Why-
scared of
why
appearing
angry?
physically, my lord.
You are looking different now.
But nobody believes that I'm a senior counsel going by my performance,
You are
which is why, my lord,
growing your
for pitiable performance, my lord. No, my lord, 20 and 21, my lord, are connected matters, my lord. The issue falls for consideration is, my lord, the requisite averments in a complaint under 138 of the Negotiable Instruments Act for implicating a director of a company.
the opposite party. Yes.
Now, my lord, as your lordship is aware of, my lord, prior to 2005, my lord, the view was that in the complaint, a director will be a party ipso facto and ipso juro, as a director is a directing mind. Your lordship is aware of that position. Now, my lord, in 2005, pursuant to a reference before the Honorable Supreme Court, my lord, a 3-member bench was constituted and the bench decided ultimately that there is no deemed liability of a director. Only, my lord, there is a deemed liability of the drawer of the secretary of the check and the managing director. So therefore, my lord, for all practical purposes, the managing.
They
I'm sorry.
appears in the complaint.
I'm sorry, my lord. My apologies.
And those directors who work day to day affairs of the company.
I'm obliged, my lord. So what will be the averment? Your lordship is absolutely right. The Honorable Supreme Court said the persons who are in charge of and responsible to will be made accused. No, my lord, then after that, my lord, the law was, my lord, pretty, my lord, consistent. But thereafter, my lord, from 2010 onwards, then again, my lord, a view that whether by saying or averring that a person is in charge of and responsible to, is this enough to prosecute a person when prosecution itself becomes worse than the punishment? Now, my lord, Honorable Supreme Court in various judgments subsequently have said that no, there has to be a detailed role of the director. Now, my lord, issue also raised that what will be the detailed role? Reason being, my lord, there is an now, an outsider is not supposed to know, my lord, what is happening inside the company, which is why, my lord, what will be the detailed role, to what extent, uh, for which detailed role, my lord, has to be specified, my lord. There was some debate. Now, in recent times, my lord, there are, to be very honest, my lord, as an officer or as a counsel, my lord, I will definitely say as a counsel for the petitioner, my lord, there has to be a detailed role, how and in what manner he is responsible. But as an officer of your lordship's court, my lord, I will say there is a cleavage of opinion. One view is that there has to be a detailed role. At the same time, there is another view that no detailed role is required to be mentioned. So difficulty lies there, my lord. There is a dichotomy, there is a cleavage of opinion. Now, my lord, there are different views of the honorable judges of this court as well, because some of the honorable judges adopted the view that there has to be a detailed role, when some of the honorable judges are of the view that no detailed role will not be required at this stage. My lord, I will prepare a compilation, my lord. I will place it on the next day. Ultimately, your lordship will decide the law. My lord, for quite some time, if I am not wrong, my lord, my dear friend Mr. Nag is appearing, it seems, for the other side. He will correct me if I am wrong. My lord, I think after 2020, post-COVID, my lord, there is no detailed judgment of our High Court on this, though there were judgments, my lord, prior to COVID. I will place all this, my lord. Your lordship will lay down a guideline for our future reference as well. My lord, what the way, my lord, I understand your lordship's court, my lord, is a constitutional court. It's not a dispute resolution center that one litigation is filed and your lordship decides. Once a judgment is pronounced by your lordship, that judgment is a guiding line for the future cases to come. No matter whether I win, I lose, inconsequential, whether your lordship allows this or rejects it, your lordship will go by the law. I am absolutely sure. I will prepare an exhaustive compilation, my lord. I will place it and I will give an advance copy to my dear friend on the next day. Your lordship will kindly give me a date. 20 and 21, my lord, both are connected. My lord, I will make joint hearing just to cut short the time, my lord, and your lordship may dispose of that. I mean, after hearing Mr. Nag, definitely.
The present case, there are 7 accused persons.
Right, my lord.
7.
Now, my lord, the company, right, but company, the managing director.
I think there is no company in
I think your
here.
lordship, my lord, just give me a moment, say, my lord. Your lordship is absolutely right. The company, the managing director, and the signatory, barring them, all are before your lordship. Which is why your lordship is right in saying no, there is no company petitioner before your lordship. Now, in connection with this,
Number
I'm sorry,
1
my lord.
and 7, who are they?
But they are mere, my lord, the office bearers of a body corporate.
They
They are mere office bearers. They are not the managing director. Admittedly, but there is no dispute on facts because my other side has not filed any opposition. I'm sorry, my lord.
They are not the director.
No, they are the director, my lord. They are not the managing director. But if managing director, no amendment is required. If signatory, no amendment is required. So therefore, my lord, I cannot argue before your lordship that for a managing director or a signatory, the amendment is required. The petitioners before your lordship are the mere directors and not the managing director or the signatory.
And
So therefore, your lordship
are not concerned about the day-to-day affairs of the company.
My lord, they, according to the complaint, the averment is insufficient to my understanding that there is no averment that they were in charge of and responsible to, and in what manner they were in charge and of and responsible to. What has just fallen from your lordship. Now, my lord, as your lordship,
Can you come to the complaint?
But kindly sees the certified copy, my lord. It's difficult, my lord. The certified copy is not marked. If your lordship sees the certified copy, sees amendment, my lord, page para 2, para 3.
They have indicated petitioner 1 is a company, petitioner number 2 Salim
Right, my lord.
Yamani director, petitioner number 3, the accused number 3 Banwari Lal is whole time director or director, and Rahul Tantia whole time director. They have said the accused number 5 as a managing director, accused number 6 Uma Shankar Agarwal as an additional director, and Sandeep Bose whole time director. Whole time director,
My
they have,
lord,
so they have indicated their role and their post in their complaint as well. Number 1. You are referring paragraph
5.
5.
I learned it referring to day-to-day affairs that happen in the
But is my learned friend appearing in item 21 as well? Because 20 and 22 are connected. I don't know whether, because there is a direction to effect service upon us, my lord. We have effected service. My learned junior will, my lord, and file the affidavit of service.
He is appearing in both matter. He is representing
Perfect. 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 Perfect.
So
So, my lord, I just tell you, lordship, my lord. I'm sorry, my lord. I'm sorry.
you are referring paragraph? Which
2,
paragraph?
3, 5. My lord, para 2, para 3. My lord, kindly says 2 to 5. Best, subject to correction.
Their awardment is that accused number 2 to 12 had requested for loan. They have mentioned about the role of their accused number 2 to 12 regarding initial request of the loan.
Right. But may I assist your lordship here, my lord? If your lordship please to pause for but 1 minute only.
Yes. Yes, you may proceed.
My lord, kindly appreciate one thing. I'm obliged. My lord, kindly appreciate. Your lordship has, my lord, found out the relevant portion, my lord. But I tell your lordship why. My lord, the averment is that subject to correction at para 5 that accused persons approach for accommodation of loan. My lord, is that, if I may ask this question to myself, is that an ingredient of 138, my lord, accommodation of loan? No. Is this a 420 proceeding, my lord? If I ask this question to myself, no. Then what is to be required, my lord, as your lordship has rightly appreciated, the role in the day-to-day affairs of the company.
No, here in paragraph 5, it was specifically mentioned that accused persons were the person in charge, responsible for
Responsible to, my lord, this is quoting of 141.
affairs and
They have
business.
just quoted it.
So how can you distinguish this?
Well, kindly appreciate if somebody only quotes this averment, because this averment, what your lordship has rightly pointed out, is found in 138 of the Negotiable Instruments Act. They have made a cut copy paste from that.
No,
Whether
did you annex your designation from where
no,
you
I have not designed. Malad, that is not my case. I'm sorry. Malad, I don't say I have designed. Malad, kindly appreciate, Malad, I'm on a different point altogether. My point is, Malad,
no,
but
no,
I think submission and cross submission, but I think Mr. Nath should argue fast, my lord.
No, I have just clarified one question.
No, if he wants to clarify, then let him do fast, because nowadays I see, my lord, this is the trend. If he wants to clarify, my lord, let him do fast, my lord. I will be the last person to argue then. No, because if I am, my lord, I can be interjected by your lordship, any question your lordship may ask. If my friend, my lord, my dearest friend, my lord, he wants to intervene, it's very difficult to concentrate.
not,
And at the end of the day, my lord, my liberty is at stake.
not interfering, sir. Please give me the answer wherefrom this court will ascertain the role of the petitioners and their designations.
I'm obliged my lord, from the petition of complaint only. Therefore, if that is missing in the petition of complaint, the petition of complaint is required to be executed with these petitioners. Your lordship is absolutely right. Your lordship has, my lord, hit the nail on the head. That is the issue. Because I tell your lordship why. Your lordship will correct me if I'm wrong. Under 130 of the Negotiable Instruments Act, unlike my lord POXO or NDPS, there is no reverse burden. Therefore, my lord, the prosecution has to my lord, place their case, and they have to show that there are sufficient material so far a particular person is concerned. My lord, I need not show or demolish the prosecution case unless I allege, my lord, my resignation. My lord, this is a case where I am not on resignation because this is not my case that I have resigned. My case is that, my lord, the petition of complaint, reading as a whole, does not make out a case in terms of 141 of the Negotiable Instrument Act as laid down by the Honorable Supreme Court of India time and again, and your lordships in this honorable court. So therefore, my lord, your lordship will consider the petition of complaint, their 200 statement, pre-summoning evidence, and my lord, the compilation of judgment which I will place on the next day, and I will, my lord, demonstrate from that. No other document is required to be seen, my lord.
From your submission, I came to the finding that your role has not been specifically mentioned. Number one, no,
Absolutely, my lord. Obliged.
they were not the secretaries of the check.
Right, my lord. Absolutely. Absolutely.
And they had no role of day-to-day affairs of the company.
As per the petition of complaint, your lordship is absolutely right.
So,
That is my submission, my lord. I need to better my submission by giving judgment.
apart from this, any other submission do you
No,
have?
no, my lord. I don't have any other.
So, next date you only produce the judgment
In
relying.
order to better my submission, my lord. I'm deeply obliged. But in both these matters, my lord, 21, 22.
God learned. Sir, 27th
My lord, 27th of, my lord,
of this
April.
month,
But 27th, I will not be, my lord. I will be in Puri.
10th April,
10th April, most obliged, my lord.
at
And my lord,
all.
my apologies, my lord. I am appearing online. Next day, I will appear physically. And my lord, my apologies to Mr. Nag also, my dearest friend. My lord, this is a difficult to appear, my lord, virtually because I could not hear him also properly. Most
No,
obliged. My lord.
next day you produce the judgment and you also prepare yourself to reply.
I will come.
Most obliged. My lord. Most obliged.
22.
Where is Sima Ghosh? He has been appointed by the High Court Legal Service Committee to represent the petition.
Number 23.
I actually, you said recollect correctly, subject to kind section of your lordship readings are completed, and Mr. Ganguly and Mr. Bhattacharya has started the argument.
Now in 23, my lord, your lordship has earlier heard Mr. Ganguly, but it was quite long back. So today I'm giving, my lord, a brief backdrop and that is involved in this matter. Now in 23, we are praying for quashing petition of complaint that was filed by the Registrar of Companies, invoking offences of sections 134 clause 8, Companies Act 2013. Now I'm not sure whether your lordship is having that Companies Act 2013. Now, my lord, kindly take note of the offences that has been complained. 134 clause 8.
So you are appearing both item number 23 and 24
Yes, my lord.
for the petitioners.
Yes, my lord.
24 cover. You are placing the case item number 24 first.
No, 23 first.
23 first. Yes, 23.
Item 23 is your 840 of 2020.
So please come to the complaint first.
Yes, my lord. Complaint is at page 27.
It's 27.
Page 27, your lordship kindly see the name of the accused.
Regarding item number 24, same complaint or same different complaint?
My lord, slightly different complaint, but what happened over here is a company, say name X. Against X, there are certain allegations that has been leveled. Now, before the allegations come into frame, what happened over here is X, there are certain creditors who moved before Honorable NCLT Kolkata against X. Now that Section 7 application was admitted. A resolution professional was allowed to take hold of the company. Then a new entity comes into play by dint of the NCLT order. That is why now
So
register of companies did not allege against X, but against Y. That is impermissible. In terms of Section 32A, the amendment that has been killed by the legislature in IBC, Insolvency and Bankruptcy Code, we have relied on Section 32A of IBC because
you
that
are not visible.
My lord,
You are not visible.
but that is the problem I am facing with the video. Sometimes it's
So I am adjourning this matter today. Next day you come.
My lord, your lordship, I will be out of session from 25th to 2nd of April. Your lordship, can you fix any date
For the second.
from 25th of this month to 2nd of April? I will be out of station. So your lordship, can you fix any date after 2nd of April convenient to your lordship? Let them complete this matter is pending before your lordship for quite some time. So I hope on the next day, Mr. Bhattacharya will be physically appear and he will conclude his argument so that I can reply on the next.
Whether company has been taken over by other company.
I will take instruction. Just
Yes, sir.
I don't remember. I will take instruction and I will apprise your lordship on the next.
So you first bring the status of the company. What is the status of the company and the petitioners?
So if your lordship permits us, we can file a status report of the company.
He will file.
He will
because
file.
he is
He will file. He will
he is representing the
Because
company as well
Yes,
as the director.
lifestyle country. I will file. Let me any date for
Now, what has fallen from your lordship, my lord, is probably dictating the order. My lord, kindly hear for once in a.
In the meantime, you produce the present status of the company as well
My
as.
lord, my lord, I'm saying so. My lord, in page 42 to 52, if your lordship kindly take note of the page in respect of item 23. Page 42 to 52 is the order passed by NCLT pertains to resolution professional, whereby the resolution professional was appointed. This appointment was done on 13/3/2018.
Yes.
Right, my lord? Now,
Yes.
this petition of instant petition of complaint, it was filed on 21/1/2020. And that is why it is barred from taking any kind of further proceeding, because we are getting immunity from 32A of IBC. The whole complex of the company has been changed, nature, status, everything changed. They cannot implicate us
Whether
for
resolution
the alleged offense carried out by the erstwhile company.
whether resolution plan was approved.
Yes, my lord. 13,
Yes,
page
when it
42
was
to
approved.
52. My lord, resolution plus, my lord, not only resolution plan approved.
I will hear you on 17th because I am facing problem in hearing you on virtual mode.
No, my lord, I would like to place it physically.
Come on physical on 17th.
My lord, kindly extend the interim order in the meantime in both 23 and 24. My lord, kindly extend the interim order in respect of 23 and 24. I will come physically on next date.
Application in both application of revisional application, CRAN has been filed.
Yes, my lord, CRAN 24.
24 and
26.
26.
Yes, they are sure.
CRAN 24 and 25 in item 23 and 24.
Order extended till 24th April. How you can initiate proceeding when resolution plan has been approved and already company has taken up.
The first time this point has been raised.
No,
Other points.
the documents have already annexed
Very
to
well,
the
I
regional
will
application.
respond on the next.
You go through the regional application and
According to
access.
Mr. Bhattacharya, the nature and character of the company has been changed. So proceeding against that erstwhile company does not like. As I
After passing the order of the, I'm glad.
I will take instruction and I will respond.
May the affidavit of service be.
Affidavit of service filed by the petitioner. This
item number 25 to 26.
5 and 26, there is no job of the opposite party. The opposite party is the complainant, they have to send a section 1.
Nobody is there from the petitioner side.
He was convicted, tried and appealed before the Learned Sessions Court. Conviction was affirmed, now challenging by order of affirmation of conviction. The restoration applications have been proceedings in respect of petitions.
Roma Roy was appointed by the legal aid service.
Subsequently, Mr. Calcutta was
Subsequently, Mr. Talukdar was appointed. Why they are not appearing even after appointment by the High Court Legal Service Authority? It is very difficult on part of the court to proceed with the matter. Despite direction, they were appointed. Do you know Mr. Talukdar?
since today there is a
Resolution after 2 p.m., not prior to 2 p.m.
first half there is a for not to pass.
Not to pass. Very difficult situation. No, not today.
I'll come back.
Please inform if you can.
Sorry.
Twenty-seven.
Number 27.
How is he?
But he has gone for a checkup, my lord. And
His operation was
yes, done. So, my lord, keeps it on the next week. Thereafter.
not this week. Today, not today means not this week. Not today.
I will not be a quality file for police. They have to file with the
28 years. The Lordship has
Heard the matter. I will continue my argument today. This is the actually
138.
yes, I am grateful your lordship has very sharp the matter. My lord, give that both of them three laws. Now
I have heard many occasions.
that's true. I will complete today.
Today you will complete.
Now, my lord, go first. Now, if your lordship kindly, I have
You have heard and then you have also submitted some
yes, I was
judgments.
starting my argument on the last one. I will complete today. I have reached everything. I have your lordship first. I want to place before your lordship the part of the examination. The part of the examination and cross-examination of figure to one for the points of liability. What has been obtained by the complainant is that my lord, I have taken a loan and in discharge of loan, I have signed the check. I was one of the directors of the company was the secretary expired. That was subsequent by an order by this honorable. Now the loan was taken and in discharge of loan, my lord, I issued the check which was resolved. That is the content. Now, your lordship, kindly, my lord, I am placing the evidence of my lord, imposition of witness number 1 for prosecution, that is Sumit Kumar Kanti Vishwas. May I read, my lord? This is very vital.
Who has been substituted, Mrs.
The years of
Gupta.
yes, the years of the petition.
Petitioner number 3,
Yes.
Gautam Gupta.
Yes.
He was
the secretary of the check.
he was the signatory of
Yes.
the check.
That is the advocate.
he was the signatory of the check. The other one is not the signatory of the check. That is Krishna.
What was the conviction?
What was the conviction?
Only compensation or some
Some more is clear. Finally, if your lordship kind comes to the order of the learned first appellate court, there is the last page of the revision application.
in default simple imprisonment for 3 months. 12 lakh was allowed compensation. 12 lakhs.
Yes. 10 lakhs was the check.
Have you deposited the
Yes, in that check. 10 lakhs was deposited. That was a precondition of the order of stay.
10 lakhs or 12 lakhs?
10 lakhs.
10 lakhs you have
Yes.
deposited.
That was a precondition. That was the order of Justice Sengupta. That was complied within the stipulated period. And that has been also annexed in the extension application also. The challenge.
What is the main ground of challenge of the
Yes, main ground is sir, I am considered. That is the reason I want to place the evidence. That is the point of liability. And thereafter, I will come to
when you have signed or signed the check,
yes.
and you have issued the check, there was a liability. That's why you have issued the check.
That's true. That I am here to not respond to what fell from your lordship. Your lordship kindly comes to the evidence.
We have annexed with evidence.
No, my lord, this is
We have not.
your lordship is
Trial court report is.
yes, that has come. I have only one.
What do you want to show in the examination?
Yes. May I guess, my lord?
Yes.
May I? My lord, this is the evidence of the one. One is authorization, then I am coming to liability.
What was the transaction?
Transaction, according to them, that I have taken the loan.
Loan.
Now my defense is before your lordship that so far the loan is concerned, my lord, nothing has been given as by my client as mortgage. This is the security check has been given as mortgage. And in the both before the learned trial court, with great respect I am submitting, my lord. If I am wrong, your lordship is here to correct it. And before the first appellate court, not a single scrap of paper has been placed by my learned friends, clients, to show that any amount of loan has been given to.
So appellate court, there is requirement to produce any document.
Before the trial court.
Trial court.
Yes. Neither before the, I am saying that neither before the trial court. And
Is
that's
there any compulsion to file the documents?
Yes, because my lord, as your lordship is very aware, my lord, earlier, my lord, the law before war class was that the complainant has to show that the check has been issued against any legal debt or liability. Thereafter, it has been, my lord, the burden has been shared. Now the accused has to show first that the check has been issued without any debt or liability. And if he is successful in proving that, naturally the burden shifts upon the complainant. Now here, my respectful submission before your lordship is that I am successful in proving that the check has been issued without any debt or liability. And the burden was shifted to the complainant. But the complainant failed to produce before any documentary evidence at the door, before the learned trial court, that I have taken in actual sense any amount of it. And your lordship kindly allow me to take the evidence. DW1, that is, show me come to discharge. Please take in the second page of evidence, page 2, in cross examination. I stated on the basis of record that the
Second file, second file.
But the second page, PW1. I'm sorry, my lord, I don't have a copy, my lord. I mean, we apologize.
এর মধ্যে নেই। ফাইলে দেখো, সাবজেক্টগুলো কোথায় আছে? সাবজেক্টগুলো দেখুন বুঝতে পারছি। হ্যাঁ, বুঝলাম। Yes,
Yes, but second page, my lord, was examination. I stated on the basis of record that the checking question was dishonored.
no, PW1 or
PW1, my lord, as far as the certified copy I get from my client, Sumi Kanti Vishwas.
Samir Kanti Vishwas.
Yes, I read. Second page,
Yeah.
cross examination.
Second page.
That starts with the paragraph I in the same bank was last page. Your lordship, what my-
Yes, yes.
Yes, I'm ready. Excuse me. Second, I stated on the basis of record that the check in question was dishonored. I have no written document to show that I have been authorized by the manager of the bank to report in the case. I cannot give the name of the officer who signed in exhibit 1. Your lordship kindly take note of it. That is his deposition in cross examination. But thereafter, your
I
lordship-
cannot give the name of the officer who signed in exhibit number
Yes, I
1.
have no written document to show that I have been authorized by the manager of the bank to depose in this case. That is there. Now, your lordship kindly come to the next deposition. That is witness number 2, Subhash Chakraborty. As well from your lordship, my lord, rightly, that who signed the check, I have stated that, Gautam Gupta, that is there, your lordship, kindly see, I received the summons. This check was issued from our bank. It bears the signature of Gautam Gupta. Your lordship, what my lord?
Yes.
Yes. Now, your lordship kindly comes to the deposition which I want to place an interest upon your lordship. That is witness number 3. That is Shoilendranath Rokhi. This is very vital. It starts, my lord, the next page. That is in my certified copy, page number 5. The line at the start. I have filed this case on behalf of the complainant company. Your lordship, what my lord? As authorized representative. This is the letter of authorization. Your lordship, what? My lord, PW3.
Cross.
Yes.
Dated.
No, that is chief. Subject to correction. My lord, dated is here is 7/8/97. It starts.
Yes, I have filed the case
Yes,
against
yes.
Krishna.
Extremely
Yes,
well.
also
I have
private.
filed this case on behalf of the complainant company as authorized representative. This is the letter of authorization. I have filed this case against Krishna and Associates and Private Limited with 2 directors. The document is marked as Exhibit 5. Now, your lordship kindly come to the next page.
See, all these are regarding check.
Yes, I'm coming to that. The point of liability, that is.
No,
the
no,
last
there
Yes,
is
I'm
no
coming to that.
denial of issuance of check from your side.
Yes,
You are saying there was no liability. So why you
Yes,
have
yes.
issued the
What?
check?
yes, that is the reason why I am raising this on my support. Of my contention I am raising. Your lordship kindly comes to the deposition dated 12th of November 97. That is the cross examination. 12/11/97, and your lordship kindly turns to page number 7. My lord, the line starts after perusing the exhibited documents. I am coming one after another, my lord. Your lordship, what my lord? After perusing in my certified copy, space 7, my lord,
Cross examination dated.
dated 12/11/97.
Cross examination of which PW?
PW3. Resume cross examination of PW3 on
1997.
7/8/99.
99, 7, 8.
7/8/99.
Yes.
Yes. The complainant company is a limited company. Your lordship, what? Yes. By virtue of board resolution, I have been authorized to file this case.
You come to the main point. Why you
Your
are
Lordship,
reading the
kindly
authorization?
hear me for a moment. I am coming to the main point. If I am wrong, your Lordship is here to correct me. I have filed that board resolution before this court. I cannot exactly remember the date that resolution. Now thereafter, your Lordship kindly come in our office. Next page, first, second, third para. Kindly see, we gave the money to the accused persons in advance account for commercial purpose. Your Lordship, what? Third para. Next page. I have not produced any papers showing the support of that fact, which my lord stated very candidly before your lordship. Now, in our office, there are papers in support of the transaction between our company and accused company regarding commercial transaction purpose. I cannot say without going through the records exactly in which period and dates those transaction papers were correspondence. I am the manager of the company. It is a fact that exhibit 5 is not the board resolution. Sometimes he said this is the board resolution. Sometimes he said this is not the board resolution. In his cross-examination, he is the manager of the company or the complainant. He is saying himself that there is not a single paper to show the commercial transaction and the amount of loan which has been given to him.
Anything else?
Yes, I am coming to the next page. Next page. I cannot say without perusing the documents in which date this amount was given by check. Your Lordship, kindly see, that is the point of liability. I have not filed any supporting document that money was paid by check. The complaint was filed and drafted correctly as per my instruction. So, your Lordship, kindly appreciate the quality of the evidence which is supported by the complaint itself.
So according to you, they have unable to
According to me, my lord, they
According
stated
to
me, my lord,
they unable
as because at that particular point of time, I couldn't produce any papers of mortgage of my property. So they say I need of money and I need of loan. That is there. So they told me immediately to give a security check so that the loan can be disbursed in my account with interest. In actual sense, that amount was never given to me and the check was gone. And for that, I am suffering. This is my point.
your argument.
Yes, there is something more. Now, kindly see his evidence. It is his evidence, the same page, page 8. Your Lordship is very kind to bear with for a moment. Kindly bear with for some time. Page 8, same time as rightly pointed out my learned junior. It is alleged our company, the same page 8 money. Our company has no any money lending license. I have not produced any document to show that was term for paying any amount of interest or any rate of interest. But it is HON'BLE that per month the accused company would pay 12,500 per month as interest. We maintain our account book. It is also mentioned in the account book as to how the amount of the accused company has deposited. Now, in this moment, it is not possible to say in which dates the accused company deposited the money. Now, your Lordship, kindly see the quality of evidence. Not a single scrap of paper has been produced. Now, I want to take to your Lordship in this point the judgments which I want to refer. But before the point of liability, I have another judgment of the Honorable Supreme Court.
Where you have said that you did not receive any loan. Do you
I have
examine?
not disposed.
No, you did not
No,
divorce.
that is the difficulty. I have not disposed.
So
What is there on, but
now
still,
how you can raise
this
this
is the point of law. My lord, I have
Point
just
of
now
law.
I have stated this is the point of law.
point of
My
law?
lord,
You did not take the
my
law.
lord, my lord, but
It's the point of law.
But they have to produce, my lord. I am successfully refuting. In my arguments, I have stated that was not considered by either of the courts. A person will be prosecuted already. I have to pay the amount of 10 lakhs as directed by this honorable court.
You did not examine yourself or anybody else.
My lord,
You did not examine from your side.
no, that was not done. What is, my lord, your lordship knows
So how you can controvert their
controversy,
contention?
but benefit of doubt naturally in my favor.
Benefit of doubt.
That will be my submission. Now, another thing, another point, I will raise the judgment of the point of liability is that if a person is not a signatory of the check, because here it is admitted fact that the signatory of say Mr. Gautam Gupta who expired, whether the other one will be liable or not. So in that score, my lord, your lordship will forgive me for the marking of the 2013 volume 8 Supreme Court cases 71.
So other legal heirs are not liable to pay.
That will be my submission. Those substitutions have been made by your lordship. Yes. A CC plus 71. Aporna A. Shah versus State Developers Private Limited and another. I will be.
Paragraph.
Yes. Paragraph 13, 21, 27, 28, 29. May I take your lordship, my lord? I will only take your lordship to the relevant paragraphs.
In this case, joint holder, only one joint holder has issued the check, where it is mentioned that the legal heirs are not liable to pay after death of the accused when the compensation was allowed by the trial court.
I have also passed, my lord, as your lordship is, my lord. So kindly bear with for a moment. Paragraph 27 onwards, page 82. I also, my lord,
Which one is the relevant paragraph?
yes, 27, 28, my lord, I am placing. Page 82. I know, my lord, why your lordship is, my lord, subject to correction is a little bit hurry because the similar point, your lordship has been pleased to deliver a judgment, which also I have against this proposition of law, where Mr. Basu was appeared, Kallol Basu. Anyway, paragraph 27. In the light of the above discussion, we hold that under section 130 of the Act, it is only the drawer of the check who can be prosecuted. In the case on hand, admittedly the appellant is not a drawer of the check and she has not signed the check. That is also my contention. A copy of the check was brought to our notice, though it contains the name of the appellant and her husband.
This provision is not applicable in your case. The conviction was against the signatories of the check.
Yes, I not the signatory.
You are not the
No.
signatories. Gautam Gupta, who is Gautam Gupta?
My lord,
Gautam Gupta.
Gautam Gupta is the managing, my lord, partner of the company who expired. And I
He
the
expired
other.
after conviction. It is not that prior to
No,
conviction.
that's true, but
So,
this is my contention. Now,
so how this contention is applicable in your case?
kindly allow me to complain.
Yes, yes.
A copy of the check was brought to our notice, though it contains the name of the applicant and her husband. The fact remains that her husband alone had this signature. In addition to the same, a bare reading of the complainant as also the affidavit of examination in chief of the complainant and a bare look at the check show that the appellant has not signed the check. This also, what tells for your lordship, is a judgment of the Honorable Supreme Court in the which has been delivered, my lord, where also, my lord, the similar facts were there. That I am not the signatory in the check. Now, paragraph 28, we also hold that under section 130 of the NI Act, in case of issuance of check.
In this case, how many accused persons?
This case, my lord, just a minute. The company, Krishna Gupta,
Company is the Krishna Gupta.
no, Krishna Gupta is the one of the managing directors, and the other one, my lord, is the secretary of the chair.
And Gautam Gupta.
Yes,
So Gautam, you are Gautam Gupta and Krishna Gupta both.
both. That is
And
the
Gautam Gupta expired
expert
after conviction.
after conviction. Thank you.
So how this judgment is relevant?
My lord, these judgments doesn't say, my lord, before conviction, subject to correction, my lord, or after conviction. What fell from your lordship, my lord?
Yes,
These
yes.
judgment says
Who
that
are the
whether-
signatories?
Yes.
He is liable for conviction. Yes.
I'm grateful.
So Gautam Gupta was the signatories.
Yes,
So he was liable.
Liable.
He was convicted.
he was convicted, but that is the thing, my lord.
Now you are the legal heirs.
Maybe, but these judgment says, my lord, what I join to your lordship, subject to correction, my lord, apart from the drawer of the check, others will not be liable. My lord, let me complete paragraph 28.
Yes, I understood your point.
Yes,
Now next
The other
judgment.
Yes. The other one, my lord, that is 2009. That is on the points, all our points of liability 2009, volume 1. My lord, Supreme Court, this Calcutta Criminal Law Reporter, Supreme Court 513 Kumar Exports versus Sharma Carpets. That is the judgment of Supreme Court, my lord. I will be taking your lordship to paragraph 22, 23.
Do you have any judgment with regard to that the convicted person if died and compensation was awarded by the trial court under section 357? Whether such compensation can be recoverable from the legal heirs?
That I will replace my.
We do not have.
Right now I don't have.
Okay, no problem.
If your lordship.
So you are only placing that those who are signatories they are only liable, and
Absolutely.
the person who are not signatories they are not liable for the
And also, my lord, the point of liability that the loan was actually.
loan was
Yes.
actually he has not received and they are unable to prove the actual
That is
liability.
their position.
That is your condition.
Yes. Now,
Okay.
my lord, I have not completed. My lord, let me place the judgment. Your lordship will not be so far. I have
Yes,
told
yes, you place your
my lord, I
judgment.
have told you.
Your place your judgment.
Because I have seen your lordship.
Yes, yes, you place your judgment. I will give you opportunity where is
Where I have seen. I know, my lord, what is really your lordship mind. That is, your lordship has been pleased to deliver. I know that. That is.
That is not the question how many judgment delivered by me on this issue. You place your case.
My lord, your
Which
lordship.
each and every case has different
Yes.
facts and
Yes, that's the reason. Your lordship kindly comes to page 520.
520.
Yes, paragraph 22. The
Yes,
defense,
22.
paragraph 22, the defense of the appellant was that he had agreed to purchase woolen carpet, your lordship,
Yes.
from the respondent and had issued the checks by way of advance and that the respondent did not supply the carpet. It is the specific case of the respondent that he had sold woolen carpets to the appellant on such and such. Now, next, on the contrary, the appellant examined one official from the sales tax department who positively asserted before this court that the respondent had filed sales tax return such and such, indicating that no sale of woolen carpets had taken place during the said assessment period and therefore sales tax was not paid. The said witnesses also produced the affidavit shown by the respondent indicating that during the year 1994-95 there was no sale of carpets by the respondent. Now your lordship finally comes to the ultimate paragraph. Paragraph 26 and 27. The court has also noticed a strange and very disturbing feature of the case. The High Court, after convicting the appellant under section 30, limited the matter. I am not on that. Now, for the last paragraph for the following, the appeal is allowed. The judgment and order such and such rendered by the learned judge of Calcutta and Calcutta is set aside and rendered by the learned judicial magistrate first class. Here also the point of liability, my lord, the complainant failed to produce by any documents that the woolen carpets were ever given or supplied to the appellant. That is first judgment. The second one is
2006, Volume 3, Supreme Court Cases, Criminal Case 30, Messrs. Narayana Menon, alias Money versus State of Kerala and another. Well, I read that paragraph 30, 31, 32, 36, 45, and 50. Well, kindly come to paragraph 36 at page 43. I will be taking only the most relevant paragraph. It was for the appellant only to discharge the initial onus of proof. He was not necessarily required to disprove the prosecution case. That is also my lord respectful submission. I am not here, my lord, as per law pronounced by the Honorable Supreme Court is concerned to disprove the entire prosecution case or the complaint case. Whether in the given facts and circumstances of a case, the initial burden has been discharged by an accused would be a question of fact. It was a matter relating to appreciation of evidence. The High Court in its impugned judgment did not point out any error on the part of the appellate court in that behalf. Now, your Lordship kindly comes to paragraph 45 and 50. That is page 40, paragraph 45. Two, your Lordship, what by
Yes.
two adverse inferences in the instant case are liable to be drawn against the second respondent. He deliberately has not produced his book of account. Just akin to our matter, he has not been maintaining the statutory book of accounts and other registers in the terms of bylaws of such and such. And thereafter, my lord, the ultimatum paragraph is 50. That is in the next page, 47. The evidence adduced by the party before the trial court lead to one conclusion, that the appellant had been able to discharge his initial burden. The burden thereafter shifted to the second respondent. In this case, he failed to do so. It is also in our case. That is one of my respectful submissions. Now, so here what I want to impress upon your lordship, that only I have to put before your lordship the parameters that check has been issued without any debt or liability, because question of liability was, I don't have to prove, my lord, with great respect, that the entire prosecution case is correct or not. That is the liability, if I understand correctly. The third one is, my lord, that is 2013 Volume 1 Calcutta Criminal Law Reporter, Calcutta 875. It is the judgment of our Calcutta High Court Justice Prosecuting, as his lordship then was, Messrs. EPJ Finance Limited. I am taking your lordship to paragraph 17, 26, and 20. 17 is at page 146. In a criminal case, the prosecution is to prove the case beyond all reasonable doubt. Whereas in a case under section 130 of the said act, the standard of proof to remove the presumption taken out by the defense is not as strict as that of the prosecution. The accused is permitted to back upon the difficult from record furnished by the complainant to remove the presumption as available under section 130 of the said act on the basis of circumstances available in the terms of section 139 of the said act. PW1 stated that they have business transaction with one TK Paul, the proprietor of Mrs. HON'BLE Auto Center, and as such the accused person issued 3 checks to the discharge his liability in personal capacity to the extent of rupees 1,50,000 on 19/3/23. What kind of business transaction they had has not been elaborated. In our case also, my lord, as if your lordship recollect from the evidence, it has been stated by the manager of the company that they have money, they have given us money for the purpose of loan, but they have failed to produce that they have money lending business. All I say. Now I'm continuing. Rather, the cross-examination of PW1 shows that it is not mentioned in the complaint as regards what specific transactions the accused incurred liability. Further, he stated that he has no more documents to prove accused liability. Also, it appears from the evidence that PW1 has not produced any document in court to prove the accused owed rupees 4.50 lakhs to the complainant. Thereafter, your lordship kindly comes to paragraph 26 and 20. That is page 883. On the other hand, the learned counsel for the opposite party states having judgments and negotiable instrument like that, your lordship is very aware. I don't want my lord. Now, 27 is also the judgment having based on thereafter total consideration 28. That is the last page 885. Total consideration of the matter suggests that the accused opposite party number 2 has been able to create a preponderance of probability. Reliance when based on the decision recording in such and such that if the defense is seen to have discharged the onus of proof, showing that the existence of consideration was improbable. It is also in my case, my lord, improbable or doubtful or even illegal. Onus would shift to the complainant. The complainant failed to establish there as a private capacity that responding how to pay 4.5 lakh in satisfaction of a legal enforceable debt or liability in a separate transaction. Rather, the respondent has showed that he along with his partner paid off the entire dues which has been admitted by the complainant. Moreover, there is no iota of evidence to come to the conclusion concern. Now, the last one.
We have sufficient judgment regarding discharge.
Yes, only my lord, after the submission of Mr. Lahiri, your lordship allows me to file a report. What?
No, not written.
No,
I don't need
No,
it.
why I'm saying because later on your lordship may say that Mr. Nikul, I have not submitted.
No, your all submission will be recorded.
That I know, my lord. That I know. I have also I subsequently appear time to time with your lordship. The point just now your lordship said that whether there is any judgment on this court that if the signatory of the check, that only I will
You can produce anytime. Yes.
Well, I don't think
Only 2 points he has raised.
the question of liability.
Liability and the legal heirs are not
that is
liable to be paid.
And the other one is so last question.
yes, double notice I am not because your double notice point I am not facing.
But he has also raised an issue regarding the second notice.
No, that I am not facing.
First argument he has raised was the second notice.
That the law is changed, my lord. As an officer of court, my lord.
Now he is
Restricting only to the liability.
2 point liability, whether you have discharge your liability to prove.
Whether I need to discharge the liability at all. Under the law, whether I need to show that the checks were issued in discharge of liability.
Liability and debt.
Whether the issuance of the check itself will carry a presumption that the check was issued in discharge of liability, and in court trial by their conduct at least has to show that this check was not issued by discharge of liability, that they have gone to me, and only then the question of receipt. So I am satisfied on that issue. And secondly, the circumstance when a person died, what will be the consequence of the said portion or the recovery of the compensation? So far as the recovery of the compensation is concerned, the responsibility of the liability of the legal heirs. But that is the next slide.
And kindly extend the interim order. I have
Sir, hearing on the this affidavit of service. How long
Item number 29.
Not today. Not today.
Thirty.
No, I did not 30 should come with suffering this matter. Suffering to high people. Is not present today, my lord, and paying
On this matter, many times we have sought for adjournment on his.
today, my lord.
Okay, not today.
Both of
31.
51 and 22 are appearing to the private and private opposite party.
What is the matter?
Okay.
This is regarding.
I wanted from your lordship today, my lord, only a small extension.
What is the matter?
The matter is complaint is one under the provisions of 420 of the Indian Penal Code, initiated by my learned friend, and the second under 130 of the Judicial Instruments Act by my learned friend. We have
Two different complaints. Two different complaints.
complaints by the same opposite party against the same position. We had filed two different CRRs challenging the proceedings.
One is complaint case, one is 130.
130.
Two different cases.
Two different cases. So the 420 was also stayed by the Honorable Court. The other ones, the 130 proceedings have also been stayed by the Honorable Court. Both are due for hearing. Honorable kindly fix a date. I am led by Mr. Gambhir. We want to continue.
the hearing was adjourned.
I understand, Honorable.
They were supposed to commence the hearing here. So many
For 1-5 day, an uncertain day, I had not instructed Mr. Gambhir. And then as I get him.
It was not earlier, no, not heard earlier.
No, no, my lord, it was not heard earlier.
The only difficulty is that the stay with the 130 proceeding, because the ground on which they have prayed for the quashing on the 130 proceeding is that the checks have been issued in not in discharge of liability but as a security. Now, the issue is this part of issue is already settled that the fee of issuing a check as a security is required to be proved during the trial. That cannot be a ground for quashing of a proceeding.
That was the exact reason why we preferred CRRs together. Because we wanted to show from the very facts of the case in 420 case that the 130 proceedings cannot lie at all. That was perhaps
the defense of the when there is a presumption as 139 that you your defense to be argued.
When both will be ready,
yes,
so that I can hear.
Let's start.
Mr. Gambhir is reading, I should not take his.
So when he will be available.
Your lordship fixes it, but accordingly we will inform Mr. Gambhir. Yes, my learned friend is also there.
24th
24th
April.
will be.
No.
Only the grand numbers of service are. Only the grand numbers.
And trend is সব ডিসপোজাল হচ্ছে না কেন? ঠিক আছে।
Item 33,
All three should be removed, all six should be considered.
For this matter, say considering on the opening for the
This matter is pending since 2022 original application.
I think not one day. Say considering is already in the letter code for is ready 2 weeks.
CD is available. CD is available. CD. Devjani Sahu, Arijit Ganguly, Devashish Roy. Okay, not today.
item 34. Our contract, the contract was environment clearance. A tender was issued for it, under the tender, a work was given. And the outside best case of financial purpose. Now, technical financial corporation has was a defined was saying that I have entered into the contract, but I have not discharged my duty. But only contractual condition. Our penalty of this person because applicant stay was contained. There was a cost of settlement and our joint petition has been prepared as part of the document. They are giving more
My lord, as of now, I went up here for the state lordship. As of now, we have not received any joint compromise application from the SI.
Lordship, I appear to the opposite party number. The company.
You give a copy to the state.
Instruction.
No, joint petition has been filed before this court.
Yes. It's a writing as
Grand Act.
8.
Where is the problem?
Lordship, we need to record a statement of both the parties,
This
lordship.
is a commercial transaction.
Lordship, but lordship, we need to record.
420 and 406. 120B. Commercial transaction, financial.
Item 35.
Mr. Mukherjee will be not available tomorrow.
So what I've heard is Mr. Mukherjee is back, perhaps from next week. He's
Next week.
physically fit. He will.
Okay, not today then.
Item 36 to 37. Getting for the state.
Your Lordship, an update on your personal registration. Your Lordship, my submitted joint work.
Subir Ganguly.
Official Mukherjee.
Ganguly Bhattacharya.
Kindly keeps the matter not to.
Okay, not today.
38 to 41.
That electricity matter, the logical call for a report from the WPS here. If there is any chance of any settlement.
Yes.
I have not received the report. I will fix it up. I have already informed them. Today, the office is closed. So, next week, I will fix the matter. In the meantime, there was a direction to take instruction as to whether they are willing for mediation or compromise or settlement or whatever.
Because four matters.
Four matters are different. There are two matters which are similar. One matter is different.
39 is different.
The first matter by law, they have
But
challenged.
all are arises from the same incident.
The parties are same.
Parties are same arising from the same dispute here.
Yes. Then
The cause of action is different, but the issue is not the same.
so if the matter can be sent to the mediation,
Yes.
where is the problem?
No, that is what I have.
Take instruction
Yes, yes.
from electricity department.
Yes, but I have already informed them that they have not implemented to me yet. So kindly keep them as the next week. In the meantime, I will
Okay,
definitely
list
get.
this on joint prayer of the learned council for the. Agree there.
The status report is different, my lord.
Your Lordship, in the last order indicated.
Status was wrongly recorded there.
Your Lordship, the order dated 20.
Status means let them take instruction.
Yes,
What would be the status of?
I will take it. On 57.
Next.
My lord, may I? I'm sorry, my lord. I think, my lord, item 86, 87, my lord, fixed today. But second up, I don't think, my lord, there will be any possibility. My lord, that PMLA matter, my lord, where I had concluded that all other proceedings are stayed. So now PMLA requires, my lord, stayed for perpetuity. So, my lord, we are protected, my lord. It was fixed today only. 86, 87. My lord, if the interim order may be extended and a time may be fixed, my lord, any day is convenient.
Red circular, this is the matter regarding red circular.
Right. Your lordship is right, my lord. Absolutely.
On many occasions I have heard this matter.
I had to submit before my lord.
I already concluded from the side of today.
Right.
So 2 p.m. fixed, you conclude today.
My lord, they also.
Resolution never end.
That is the date and time.
My lord, fixed.
Well, since your lordship will be taking up, my lord, these matters throughout the day, my lord.
Matter.
So, right, my lord, can it be on at the first half of the some Friday, my lord?
I have fixed this matter. I heard.
So now my lord, fixed it on 10th April because next week also the Ramnavi etc. is there and then week later is Good Friday. Kindly fix it on 10th April.
The second half I will take up this matter. Anyone
But
can-
fix is that to them, man.
No, I am not passing any order. I will not reach.
Well, the interim to be extended, my lord. Only, my lord, which is why we are requesting, my lord.
He can also go, man. Whatever it was, picks up all the.
No, no, 10th April, 2 PM, we could not.
So I will take up all the interim orders matter at 2 p.m.
No matter.
My lord,
Now I have to have my lunch.
Well, it's already submitted, your lordship has already taken off.
Anyone can come and I will dictate.
Well, Mr. Pushkar also has
No,
brought.
I will dictate. I have heard. Anyone can stand. I will dictate after 2 p.m.
okay, oblige, man, oblige.
This is not the time for listening.
This is actually item number 92, it is appearing in today's list. Mr. Shabir Ahmed had previously argued extensively in this matter, my lord. I'm just praying that this matter could be fixed on some other day. Mr. Mohi,
Let me call the list first, thereafter I will listen. Whenever I will reach the matter, you will listen.
October item number 90.
And when we wanted the track record, I found it. Keeps it, but kindly makes this observation or a direction for the LCR, passing the short date, because on that day, on the LCR.
There is no other side.
But statements here, they have appeared already, names have been given.
Item number 42.
What parties are available?
The Krishna Pradesh is trying to but the difficulty is to 130 proceeding concurrent.
But now today I cannot take actions of other. I am only keeping not today.
Can you fix at the clock?
No. Already top 42 I can reach.
Whatever.
Yes, next.
43.
44. देखो ना call list. Why you are not looking at the call list?
45. 46. 47.
Lord, I have to petition at 47 because the entry order has expired. Now, Lord,
Who is the other side?
state.
Let them come and you file affidavit of service on the urgent date.
Lord, affidavit of service is there, Lord. We were supposed to serve.
But today I cannot pass in absence of other side. You are you sir.
Okay, Lord, fix it on
Already matter is to stay. Where is the
Lord,
question of fixing?
as per this application, any day.
No, I will take up, no problem. Next Friday I will take up. You will be present, I will be taken.
Item 58, Lord, is 47.
I will call, I am calling. Next.
48. 49. 50. 51. 51.
51 and 52 first.
51, 52, then we are only 52.
Who is appearing other side?
Mr. Kunderi, I have mentioned.
So this one.
Only one link to modesty. Till the 27.
Both are passing analogous order.
Yes, sir. Analogous orders. One is the content application arising out of the CR. This is the CR. Next. 3450.
Yes, affidavit of service file. By the petitioner. Because this is not possible for
53. 54. 55. 56. 57. 58.
Lord, for extension of entry order.
other side is there.
59, 60, 61, 60, 63, 64, 65, 66, 67, 68, 69, 70, 77. It's one can spin the 7, 8.
Already expired, no?
No, 27.
March.
Lordship keeps it on the same date, same time.
71, 72, 73, 74, 75.
Well, this is why individuals are the last profession.
Where is the other side? Where is the other side? Not today, next day,
No, make it one. Next Friday.
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 You mention, I will allow.
Individuals are in the beginning.
You inform other side. It will be taken up on that day,
Individuals,
out of town.
individuals are the matter of that.
On that day, I will take it.
Of that.
If both party will be there, then I will take up. Otherwise, I will not take. Next.
76, 77, 78.
Yes. Not today.
79, 80.
My lord, 80, I am appearing for petitioner, my lord. This is the matter in which learned senior counsel Joyanta Mitra is arguing on behalf of the petitioner, my lord. My lord, his learned junior Proka Bhaumek has undergone a surgery, my lord, and she is under bed rest. Mr. Mitros has requested my lord to pray before your my lords. If your my lord can take this matter in the month of April, my lord.
Monthly list of May or April.
April, my lord.
So I am fixing a particular date.
Yes, my lord.
9th April,
Yes, my lord.
2 p.m.
Yes, my lord.
Because I have already heard this matter.
Yes, my lord. Yes, my lord.
Okay.
Yes, my lord. Grateful to your lordship, my lord.
19th, 9th April. Read matter. Not today. Very, very difficult. Maybe, but you have to mention after notice to the other side. You mention after notice to the other side. How I can upgrade without informing other side? Yes, next.
81, 82, 83, 84, 85, 86.
86 and 87, my lord. This is the picture of the morning, your lordship.
There is no crack.
My lord, no crime because today was supposed to be heard out, my lord, because of the difficulties.
The interim order is
Interim order is
exists.
27, my lord, let that be extended. 10th, your lordship has already.
27th I will extend. Why you
My
are
lord,
asking for
is
extension?
the person who is arguing, my lord.
27th I
He has
will hear
already
it out.
made this submission. My lord, kindly keep it on 10th, and your lordship had actually.
27th I will be there. You will be there
My
also.
lord, kindly keep it on 10th, my lord, because again, our time is short code, I need to know what is the.
On consent of the parties. Appearance করে দেবো না?
88, 89 with 90, 91, 92.
We never had argued extension of this ordered matter.
Ballot, I'm saying that this matter be fixed on any particular date.
What is the matter about? Can you?
Well, it is about washing of 498A, 406 FIR ballot. The petitioner
This is under heading part heard. It will be taken up. Where is the problem?
actually the petitioner is also facing appeal proceedings in DTI. There, my lord, there has been raised a demand for maintenance of 80,000 rupees, but all my source of income, my lord, I have has been shut out because of my wife's actions, my lord. Right now I'm more source of income, and I have also
You saw the notice to the other side and you answer. I will ask you. Okay, you solve and thereafter I will.
93, 94, 95, 96, 97 with 98, 99, 99 with 100, 101, 100,
101. What is your prayer?
Sir, I'm praying for a data account.
103, 104, 105, 106, 107, 108, 109, 110, 111,
Not today.
112,
Not today.
130,
So
114, 150.
yes, not today.
115, 116, 117, 118, 119, 120, 121, 122, 123, 124, 125, 126, 127, 128, 129, 130, 131, 132, 133, 134, 135, 136, 137, 138, 139, 140, 141,
Say,
142,
say,
143, 144, 145, 146, 147, 148, 149, 150, 151, 152, 153, 154, 155, 156, 157, 158, 159, 160, 264, 63, 164, 165, 166, 167, 168, 169, 170, 171, 172, 173, 174, 175, 176, 177, 178, 179, 180, 181, 182, 182, 183, 184, 185, 186, 187, 188, 189, 190, 191, 192, 193, 194, 195, 196, 197, 198, 199, 200, 201, 202, 203, 204, 205, 206, 207, 208, 209, 210, 211, 212, 213, 214, 215, 216, 217, 218, 219,
220, 221, 222, 223, 224, 225, 226, 227, 228, 229, 230, 231, 232, 233, 234, 235, 236, 237, 238, 239, 240, 241, 242, 243, 244, 245, 246, 247, 248, 249, 250, 251, 252, 253, 254, 255, 256. 257, 258, 259, 260, 261, 262, 263, 264, 265, 266, 267, 268, 269, 270 to 71, 272, 273, 274, 275, 276, 277, 278, 279, 280, 281 to 289. 290, 291, 292, 293, 294, 295, 296 to 297, 298, 299 to 300. 301, 302, 303, 304, 305 to 306. 307, 308, 309, 310 to 322. 323, 324, 325, 326, 327, 328, 329, 330, 331, 332, 333, 334.
Well, actually, exceptional in 81 and 85. 81 and the very part of the university of Christ together is a university application for the reason. But as you know, in the first half, the first issue, the method was called as per time, another method. Now, so far 85 is concerned, university kind of passing petition on behalf of the teacher. I was making my submission, I made extensive submission. There has been subsequent development of facts, which I want to bring to your attention, that that in the said case, even after lapse of 3.5 years, even though I have obtained the certified copy of all orders, no prayer even was made for extension of time to carry on the investigation. So, the provisions of the scenario has already been changed. One of the persons, accused persons to whom alleged to have, my client has alleged to have been conspiracy, he has been discharged to the time. And the stop the investigation by taking reports to the provisions of 167 subsequent 5. Clause 2. So, the lordship present to, I do not know whether lordship used to sit in the next week, Friday.
Friday I will be taking. Friday I will be taking.
Then I will come up with this, with this, then if the investigation itself has been stopped by the honorable trial court and trial court, because of the fact that that the investigation could not be completed within the statutory period, and even no application was made.
So one person has been discharged, and he is the another one.
He is the another person. He is the person who purchased the blood by paying EMI, so and so. These are the merits of the case.
So you go before the trial court, you withdraw this case.
No, not that your lordships can pass this order. It's a purely a question of law. If a person, if the charge sheet is not filed in the statutory period, and no application is filed on behalf of the investigating officer
Even
for extension of time which will appear from the records itself, my lord, then the case cannot continue. This case itself cannot continue.
bring also order of the trial court.
Yes. I think that would sort of, and also the all the order sheets I have obtained here, in not
This is item number 85.
85. In
Not
not a,
for the petitioner.
yes, not a single petition was
For
filed.
the opposite party,
Lord,
Anand Kesari.
Mr. Anand Kesari. Lord, not a single petition was filed on behalf of the investigating officer for extension of time. That's
In
one,
trial court.
yes, 167 subsection 5 clause 2 applies to her. This is purely question of whether if that's why you done it, they also stop the investigation.
Above 3 years.
Yes.
He must have pray for extension.
Yes.
For
Yes. Unless if it is not done, it is purely question of law, you have to decide very much. I will not refer to the certified copy which I have obtained. All the orders are up to date from the time of taking bail.
May I upgrade this?
Hello?
May I upgrade this matter? So that
Subsequent laws and coordinate is possible.
85.
85. So that because the purely question of law, that it can be decided by your
One
laws.
person has already been discharged. Similar case, same case.
Same case.
Same case, same FIR.
Yes, same FIR. And the learned trial court has been pleased to stop the investigation or directly stop the investigation because statutory requirements has not been fulfilled by the investigating officer. He has been discharged, he filed the discharge application. Without it, even if that 167 subsection 5 clause 2 applies squarely. If the investigation is not completed in a specific period without making any application for extension of time, that proceeding cannot stand or allowed to continue.
Contested application. So at top for the, you inform the Mr. Case.